Hello everyone, my name is Aurangzeb and in this session of video we will be talking about the international law in international relations, that is the impact of international law on the war between Ukraine and Russia. So let's start the video and understand the topic international law. Starting with the definition, the term international law was first coined by Jeremy Bentham, the great utilitarian of England. The subject is related to the social sciences and thus difference about definition among scholars is a natural phenomenon. Different writers have given different definitions of subject. Oppenheim defines international law as the name for body of customary and conventional rules which are considered legally binding by civilized states in their intercourse with each other. In the words of Swanwick, it is a body of rules accepted by general community of nations as defining their rights and the means of procedure by which these rights may be protected or violation of them may be redressed. Briefly says that international law is a body of rules and principles of actions which are binding upon civilized states in their relations with one and another. Stark has offered much wider and comprehensive definition of international law. According to him, it is that body of rules which states feel themselves bound to observe and therefore do commonly observe in their relations with each other, and which include also the rules of law relating to the functioning of international institutions or organizations, the relation with each other and the other relations with states and individuals. B. Certain rules of law relating to individuals and non-state entities so far as the rights and duties of such individuals and non-state entities are the concern of international community. According to Lawrence, international law is rules which determines the conduct of general body of civilized states in their mutual dealings. To sum up the above definition, we can say that international law is the body of generally accepted principles and rules controlling the conduct of national states, non-states entities, international organizations, individuals and corporations. Now we shall understand the sources of international law, that what are the sources on which international law depends. Sources may be defined as a starting point or starting place from which some thing comes or is obtained. The international law as a subject has come out from different sources. At present, the statutes of International Court of Justice is an authoritative text of sources and evidence of international law. Article 38 of the statute stipulates that it shall apply to international convention, international customs, evidence of general practice accepted as law, the general principles of law recognized by civilized nations as the main source, the judicial decisions and teaching of publicists and text writers as a subsidiary means for determining the rules of law. In simple words, the sources of international law are treaties, customs, general principles of law, judicial decisions, and textual and research work of jurist writers. They are as discussed in detail. Now let's discuss the sources of international law deeply. Treaties are the part or source of international law. International treaties and conventions are the most important part of source of international law. There are two types of international treaties: law-making treaties and treaty contracts covering special matters between contracting states only. Out of them, law-making treaties are the source of international law. The law-making treaties involves two operations. a legislative operation whereby the rules are laid down and undertaking of contracting parties to these rules. Treaty of Westphalia 1648, Treaty of Paris 1815, Treaty of Versailles 1919, Declaration of Paris 1856, Geneva Convention of 1864, 1899 and 1907, the Covenant of League of Nations, Charters of UNO, etc. are the examples of law-making treaties. General principles of law. The general principles of law, including principles of equity and justice and universally accepted principles of constructions. They also include the principles of private law administered in national courts. This source allows international law to determine international disputes according to the fundamental legal principles. The adoption of general principles of law is useful in new areas of international law. Judicial decisions. Now, the third source of law is the judicial decision. So, let's understand what are the judicial decisions. Article 38 of the Statute of International Court of Justice refers to judicial decisions as a subsidiary means for the determination of rules of law. However, Article 39 provides that it has not binding force except between parties, and even parties to the disputes it will bind them in respect of that particular case. Although the judicial decisions and precedents are not binding here in international law, the practice of referring to them has become binding. One of the most conspicuous features of the judgment and opinion of the court. Now let's understand very important topic, that is nature of international law. There has been constant debate among the jurists and scholars about the nature of international law. There are two schools of thought on the topic. They are Australian school of thought and modern school of thought. The Australian school of thought doesn't regard international law as a true law, and it is not prepared to give it the same status. The thinkers like Hobbes, Pufferdorf, Austin, Holland, Zeman, Willoughby, etc. belong to this school of thought. According to them, international law is not a law but international morality, consisting of opinions and sentiments prevailing amongst sovereign nations of the world. It is not binding as it is not supported by the statutory of the states. The sanctional force, which is the base of law, is lacking in the field of international law, and the law breakers generally goes unpunished. Moral force is the only force in international law, thus it is not a law but morality. Modern school of thought differs from Australian school regarding the nature of international law. The writers belong to this school include Hall, Lawrence, Opinion, etc. They maintain that international law not only operates as law, but it is distinct from international morality in its nature as well as in its sanctions. The modernists give different definition of law according to Opinion. Law is a body of rules for human conduct within a community which by common consent of the community shall be enforced. Thus, according to the modernists, the family of nations may be regarded as international community where certain rules have been grown up to the govern interstate conduct. The enforcement of these rules is sanctioned by the consent of international community. The modernists explain that the only condition for the existence of law is the existence of political community and recognition by its members of certain rules binding upon them in that capacity. International law satisfies these conditions and thus it is a law. This school of thought opines that consent and not force is the base of law. To sum up, the modern school of jurisprudence, adequacy of law is a function of its acceptability, its just nature and its enforceability, and international law like municipal law pass this threefold test. My only purpose of making these videos on international law and such other subjects is to just spread the awareness among the laymen and let them inform about the laws and the procedures. I would be happy if you contact me through my this video, and in comment section you may ask such relating questions and you can contact. I would request you for liking this video and subscribing my channel, and if you have any other question regarding the subject or the topic or any other question regarding my videos, you can comment in my video section and comment section, and you can ask anything if you want. Take care and